Be here. So children's rights are really close to my heart. I'm especially specialized in children's rights at school and the Convention on the Rights of the Child, but I have also written a little bit on children's rights in healthcare, and that's why we got interested in this topic with Merike Helander in 2017. So from the legal point of view, non-medical circumcision of boys based on religious and cultural traditions has become under criticism only after the legal status of the child began to take shape in accordance with the Convention on the Rights of the Child, CRC, which was adopted within the United Nations in 1989. The CRC reflects a comprehensive child rights perspective, obliging states to pay attention to the unique legal status of a minor. Since the child is regarded nowadays as an independent holder of rights, so there's kind of no question of that. According to international law, child is an independent holder of rights. Interferences with rights by guardians, parents, are also considered as potential violations of rights. There is no consensus on non-medical circumcision of boys in Finland or in Europe, not to mention worldwide. No international human rights instrument clearly prohibits circumcision of boys. In its judgment in the case of Jehovah's Witnesses of Moscow and others versus Russia, 2010, the European Court of Human Rights referred to circumcision of boys practiced by Jews and Muslims as an example of a potentially harmful ritual. The UN Committee on the Rights of the Child, later in my presentation I call it the Committee, which is monitoring the implementation of the CRC, has remained silent on circumcision of boys in its general comments interpreting the Convention articles. The Committee has mentioned circumcision in its concluding observations to the State of Israel. The Committee expressed its concern about risks of complications associated with some traditional male circumcision practices. The Committee did not, however, take any stand on the acceptability of circumcision itself. In the Nordic debate, circumcision has been considered to violate child's right to health, child's physical integrity and privacy, child's right to self-determination, and child's right to be protected from all forms of violence. Nevertheless, the Supreme Court of Finland considered in its decision in 2008, decision 93, that circumcision of a male child, even though it clearly fulfills the essential elements of assault per se, is not punishable in a situation where it can be considered to be in the best interests of the child. And that's interesting, of course. When can violating somebody's rights be in his or her best interests? In my presentation, I will first list some basic elements of the unique legal position of a minor, because it's exactly the rights of the child that must be the starting point when talking about this topic, not the rights of parents like it often have been done. After that, I will present the relevant rights that are at stake when considering the legal permissibility of the circumcision. The question is whether the removal of a child's healthy tissue without the child's consent and without significant medical benefits is a private matter to be left for the parents to decide, or whether interference with the rights of the child must, in this kind of situation, be regarded as an illegal violation of children's rights. And I want to note that I'm talking only about non-medical circumcision of boys. I will be referring to three decisions. We have three decisions on the matter from Finnish Supreme Court, and we'll be a little bit jumping to them during my PowerPoint presentation. By the way, I often go to South Africa, so this one picture here in the first slide is from South African initiation school. So, there are several elements that distinguish minors from adults in respect of their legal position. First, minors have been guaranteed many more rights in legislation and international instruments compared to the adults. This is true also about human rights. The aim of this is to give minors special protection. So keep this in mind. Minors have special protection in this world. So we have to keep this in mind also when we talk about circumcision of boys. Another important difference between minors and adults is that children lack full legal competence, making them dependent on the decisions and actions of parents and other adults. Therefore, special measures and activity can be expected from, for example, legislature, public authorities, and courts to realize children's rights and make sure that they are not violated. Thirdly, children's developmental state makes them particularly vulnerable to human rights violations, and that the effects of violations can be more severe and longer lasting compared to adults. This is, I think, very important in case of male circumcision. The fourth difference is that because of the lacking legal competence, minors don't have independent access to justice, which is quite problematic because it's a core thing in our society. So they don't have access to justice when their rights are not respected. They can't themselves usually react or can't be expected to react in the case their rights are being violated. I wanted to take this slide here because I've seen that when I go and talk to people about children's rights, it's often forgotten that children, as legal persons, they are quite different from adults. They have very special protection in international norms and also in national legislations. So then I'm going to talk about the rights of the child that are at stake in this context. First, right to health. According to the Article 24 of the CRC, the child has the right to the enjoyment of the highest attainable standard of health. The right to health has been regarded as a strong argument against circumcision because of the health risks the operation involves. The right to health includes the right to exercise control over one's own health and body, and the right to forbid other people from violating integrity and the right to privacy. The Council of Europe resolution on freedom of religion from 2015 draws attention to the child's health. According to the resolution, circumcision of boys should not be allowed without ascertaining that the person performing the operation is competent and circumcision is performed in appropriate and safe circumstances. In its decision from 2008, I show here the decision. I will come back to it later. In this decision, the Finnish Supreme Court considered that the circumcision performed in an appropriate manner does not cause any damage to health or other permanent harm. But, well, we can, of course, disagree on this. There wasn't really much about that issue, not many arguments for that result. Then another important right is integrity and privacy. The debate on circumcision of boys has given most attention to this right to integrity. The child's integrity and privacy are fundamental and human rights that belong to the child in person. In the case of small child, however, the parent is entitled to give a permission to, for example, operations interfering with physical integrity, if they are necessary or important for health. A circumcision for non-medical reasons is not, of course, this kind of operation. It is very clear also in the court praxis of Finnish Supreme Court that circumcision constitutes a violation of integrity. The Council of Europe Parliamentary Assembly adopted a resolution on the right of the child to physical integrity in 2013. The resolution considers that practices violating the physical integrity of children are worrying, citing as examples female genital mutilation, operations performed on intersex children, piercing and tattoos, as well as circumcision of young boys for religious reasons. And so member states are called to raise awareness of harmful practices and to take measures that help reinforce child protection in this context. The resolution doesn't, however, include a recommendation to ban circumcision of boys. In this decision that I already talked a little bit about, Supreme Court of Finland stated that the quality of integrity violation is essential in the assessment of its illegality. A serious violation of integrity is not acceptable. The Supreme Court decided to consider circumcision as a relatively minor violation of child's physical integrity, provided that the operation is performed in appropriate manner. The court further noted that circumcision is not associated with any aspect that would stigmatize the child or the adult into which he will develop. Yes, I wonder what do we know about this, and for example, have the opinions of boys, young men who have gone through this, have they been somehow collected, and do Supreme Court know about those views? I think I doubt that quite a lot. And one very important element in children's rights is that the child should be always asked about his view about anything that is happening to his rights. Of course, we cannot ask a baby, little Jew baby, anything, but we can, of course, do a lot to collect views of men who have been gone through this operation. How did they feel afterwards in life? Then, I think this is very important right that hasn't really gotten enough attention in this world yet, comes from CRC also, is protection from violence and harmful treatment. Because the Convention on the Rights of the Child, especially Article 19, emphasizes the protection of child from all harmful treatment, not only violence, everything that can be harmful, that the child feels somehow harmful. And the Convention does that more strongly than any other human rights instrument. The Committee on the Rights of the Child states that the concept of violence is broad, including, for example, all forms of physical and mental violence, injury, or maltreatment. If circumcision of a male child was considered as violence or harmful treatment referred to in human rights treaties, it could not be permitted at all, since the Committee on the Rights of the Child has underlined that no kind of violence and harm against a child is allowed under any circumstances. The child's right to protection from violence and harm cannot be limited based on the rights of other persons, states the committee. I think that's quite important in our context here. Then, the right of the child to have his or her views taken into consideration. I already mentioned a little bit about this participation right. It's Article 12 of the CRC that expresses one of the core principles of a modern child law. According to this article, every child who can form his or her own views shall have the right to express those views freely in all matters affecting the child. And there's also obligation to give the views of the child due weight in accordance with his or her age and maturity. In its resolution, the Council of Europe Parliamentary Assembly has called member states to increase awareness about the right of the child to participate in all decisions interfering with their physical integrity, wherever appropriate and possible, and to adopt legal provisions to ensure that certain operation will not be carried out before a child is old enough to express his or her views. In the case of decision of Finnish Supreme Court, let us see another one here from 2016, decision number 24. The circumcised boys were 7 and 12 years old at the time of operation. The Supreme Court stated, I think referring to the smallest child, it's a little bit unclear from the decision, but probably to this 7-year-old child, that it's not small child is not in a position of forming a spontaneous and independent understanding of an operation like circumcision with permanent implications and of its religious content. The Supreme Court noted that if a child can assess the meaning of circumcision, his opinion must be crucial in the assessment of the justification for circumcision. But in Finland, well, we have funny age limits. Here, the legislator thinks that you have to be 18 before you can decide yourself if you want to belong to some religious community or not. Before that, you have to do what your parents have chosen for you, because when you're at the age of 17, you are not mature enough, to understand. So now I'm a little bit, talking about this, but I think we have quite severe problems with these age limitations. And here we come to the freedom of religion. That is usually, it has been considered as adults' right, and it has been discussed from the point of view of parental right to give guidance for their child in religious matters. Nevertheless, nowadays, even freedom of religion is considered as a very personal and private right, and also right of each child. According to the Article 14 of the CRC, the child shall have the freedom of thought, conscience and religion. And according to the committee, it is the child who exercises the right to freedom of religion, not the parent. And the parental role necessarily diminishes as the child acquires an increasingly active role in exercising choice throughout adolescence. Also, in matters concerning the freedom of religion, it's essential that the views of the child are given due weight. And I think it's interesting to note that the committee has, in general, been very concerned that states do not pay enough attention to the individual freedom of religion of children in the legislation. Okay, these were important children's rights when we think about male circumcision. Then we go to the rights of parents, because parents and their rights and duties have to be taken into consideration in all matters concerning children, because children don't have the full legal capacity. But how do we take them into account is, of course, another matter that we can discuss. So first, there's the right to make decisions on behalf of the child, but they must be in the best interest of the child. That is interesting. By the way, Finnish law concerning the role of parents doesn't include even the duty to act in the best interest of children. We tried to propose that into legislation when that law was amended in 2019, but that was thought to be somehow so self-evident or something, so it's not there. It's a little bit, I can't say really funny, but it's quite odd, because it's a clear duty also in the CRC. I think this is about the old traditions. We don't want to put that kind of thing to this kind of law that regulates relations between children and parents. Well, the parent's position is rather strong under the provisions of the CRC. According to Article 3 of the CRC, the state shall take into account the rights and duties of parents. On the other hand, parents' right to bring up the child is restricted by the obligation imposed in Article 18, which is important, to act in the best interests of the child. In respect of circumcision, it's necessary to consider whether circumcision compromises the child's development and well-being, or whether it supports these and is therefore in conformity with the best interests of the child. Anyways, parents must ensure that the realization of all the rights of the child, and they cannot violate these rights by referring to their upbringing, responsibility, or right. In connection with the decision on circumcision, the guardians must together ensure that the child's right to health, integrity, privacy, freedom of religion, as well as the right to have his or her views taken into consideration are realized in an optimal manner. That's a duty of parents, even though they don't know about it usually, but that is how it is legally. The primacy of the best interest of the child means that when a matter is decided, the interest of the child must be given greater weight than any other interests, for example, parents' interest involved in the matter. The Finnish Supreme Court has based its decision on the presumption that the right of parent to decide on circumcision of their male child must be specifically assessed in respect of the best interest of the child. For circumcision, To be acceptable, it must not only be the best solution from the family's point of view, but also be in the best interest of the individual child when assessed objectively. In this decision from 2008, Supreme Court stated that the violation of the child's physical integrity is justified for a non-medical reason only if it's clearly and unambiguously in the best interest of the child. It's interesting that according to Finnish legislation, in a matter that is of great significance for the future of the child, the persons having custody, usually parents, may only make a joint decision unless it's manifest that the best interest of the child do not require this. The Supreme Court has stated that circumcision for non-medical reasons must be regarded as this kind of matter, and guardians may only make a joint decision. In this decision, on this slide, the child's father, who had the circumcision performed without the other guardian's consent, had acted contrary to the cooperation duties. The Supreme Court found that the defensibility of circumcision cannot be regarded as sufficiently clear in terms of overall interests of the child if the operation is based on the religion or culture of only one parent and the other parent objects to it. So we have these decisions where there are two parents, then it's okay. Two, if they agree. Two parents, if they disagree, then it's not in the best interest of the child. And then the first one, this from 2008, there was only one parent, only mother existing. So that is also maybe important to notice. Well, then shortly about right to religion and culture of parents. According to the CRC, the parents have that right and duty to provide direction to the child in the exercise of freedom of religion in a manner consistent with child's evolving capacities. CRC also states that a child belonging to a minority or who is indigenous shall not be denied the right to enjoy his or her own culture, to profess and practice own religion or use own language. Practicing a religion must support the right of the child to growth and development to their fullest potential. It follows from this that parents' guidance and practice of a religion may not include, for example, any kind of mental, physical violence or ill treatment. The necessity of circumcision has been justified by arguing that it joins a child in a religious and cultural community and thus reinforces sense of belonging to the community. It is considered important that the child feels belonging both to the family and the community in question. The Finnish Supreme Court has considered that the child's attachment to family and, for example, ethnic group can be regarded as a target compatible with the overall interests of the child, which may influence the assessment of the operation's acceptability. It must be highlighted that according to the Committee of the Rights of the Child, practices related to preservation of religious and cultural traditional values which are inconsistent with any rights established in the CRC are not ever in the best interest of the child, which is important to note, I think. The debate on circumcision in the Nordic countries over the past few years has been strongly based on the protection of the child and draws from the premise that circumcision violates the child's integrity and cannot be allowed based on the rights of the parents or by referring to the best interest of the child when the best interest of the child are linked with the parents' religion or culture. Nevertheless, Supreme Court has these decisions which are not in conformity with, for example, how the researchers on this field think. International law would seem to give the parents the possibility of deciding on circumcision, at least when the child is too small to understand himself the significance of the operation. In children's rights research, the challenges to change traditional practices and culture of public authorities, for example, education providers, child protection, healthcare, have been recognized. We often see that the what is este in the obstacles, realizing children's rights are these traditional practices. And I think it's also the same with circumcision. It's a lot about traditions. Traditions play a role also in many levels of the legal system. They are present in lawmaking, kind of traditional values. They are present in implementing law in courts, like I think in our Supreme Court, in the actions of public authorities, and in legal research, of course, also. When it comes to the legal position of minors in general, traditions have been clearly changing. We have seen them changing during these last 30 years. There are several traditions and practices in families and in public domain that are nowadays seen as clear violations of rights when before they used to be part of normal life. And this will probably be true in the context of male circumcision as well. I think that it is on its way to change this whole matter. In this era of human rights, when taking into consideration child's rights to non-discrimination, all minors have a right to expect that their rights are not violated, it seems quite obvious that even an ancient traditional religious or cultural tradition is not anymore a valid legal argument. It cannot be anymore a valid legal argument for violating anyone's, adults or minors' right to health, important right to integrity, right to protection from harm. Also, we say that we are protecting, giving special protection for children. Also, children's rights are not anymore in the pocket of their parents. Also, we already understand that children's rights are not mini rights, but as full as important as adults' rights. In case of male circumcision, both local and global dialogue is needed, and I want to thank Intact and Johan for organizing this kind of event for discussion and for asking me to participate. Thank you so much.
Thank you. That was very, very interesting. I was wondering, I think you more than implied that the verdicts by the Finnish High Court were not necessarily in compliance with current understanding of rights in a children's rights perspective. How do you propose to bridge that gap between legislative practice and legal practice on one side and understanding of rights on the other side? And well, after that, I'd like to ask another question, actually.
Yeah. Okay, thank you. Well, first of all, I would like to note that I think that it might be that the sentiments, kind of ideas in Supreme Court concerning this topic might have been changing from those cases, because it's only from 2018 on that we have really seen that the Supreme Court has begun to refer to the Convention on the Rights of the Child and the general comments on the committee. So there has been clearly, just in very recent years, a change. So I think it might be that if this kind of matter would now come to the table, the decision might be different. One thing that is interesting is that the Supreme Court mentioned in that first decision, and I can't remember if also in the others, that legislation is needed on this matter. They thought that it's not ideal, it's not sustainable that we should kind of evaluate this kind of matter each time individually, because there's no legislation really. One thing I would like to say here, I was just in this children's rights research group before I came here, and there was this researcher who has been writing her thesis best interest of the child, and we were talking a lot on the best interest of the child. And she mentioned that one thing that is quite difficult when we are assessing the best interest of the child is that the Committee on the Rights of the Child hasn't given any criteria in which cases it's possible to limit those rights. And now they are being limited. We know that, for example, constitutional rights can be limited if there are certain requirements are met. But we don't have this kind of requirement when it comes to CRC, so that makes it a little bit more problematic. But as you heard when I was reading these different papers from committees and European Court of Human Rights and so on, it seems that we are kind of having this double standard. We said, no, children, we cannot violate children's rights in any way, and still we are doing it. I mean, and very kind of this basic core right, like physical integrity. One thing I also would like to mention that in these Supreme Court cases, there was no mention really about, for example, the consequences for sexual health of a man. So I think this has totally been, what is Johan sivuuttaa in English? Sivuuttaa. It has been put aside, yeah, which is quite interesting. Like we would be dealing, only with kind of small babies and thinking this from the baby's perspective only.
I'm teeming with questions.
Yeah, that's great.
Some of them to you, and I was wondering if maybe I might pose a few questions to Brian later on. Okay, so you said the High Court said that it called for legislation on this area, but said there's not currently any legislation. But you have a penal code that prevents bodily harm. Is there any comment as to why that wasn't applied in this issue?
Well, this was a kind of as a penal code issue in the court, but they had to assess this best interest of the child. So it was considered as an assault, but it was thought that it's permissible because there's this parents' right to educate and kind of to raise child to their own religion and so on.
So am I correct in understanding that they sort of called for the invention of legislation regarding certain types of permissible rights invasions or rights violations?
Yes, I think that the idea is that there would be there are now some recommendations from Ministry of Social and Health Affairs. So I think that the court meant that that kind of recommendations should be in law. It should be legislation. And I don't think that they were willing to prevent circumcisions. They were just wanting some guidelines how to do them. Yeah.
Then I have a comment and another question. So the comment is, you mentioned that the UNCRC had asked Israel to consider harm and complications in the context of non-therapeutic male circumcision of minors. As far as I remember, they were supposed to include it in their state report in 2020, as far as I remember. And I think it was postponed 1 or 2 years, and now it's postponed indefinitely. But what work was going on in order for them to explain themselves, but also there were some NGOs planning to respond to that. And that leads me to the next question. In Intact Denmark, we have actually reported to the UNCRC on this issue. We made a very, very thorough report, and they responded to it by inviting me to present the report to the UNCRC in Geneva. And 2 weeks later, they withdrew the invitation. They wouldn't give me the reason in writing, but on the phone they told me that they withdrew because the Jewish World Council had opposed my coming there. So the discussion is going on in the UNCRC, and also the UN Special Rapporteur on Religious Freedom visited Denmark and had meetings with a lot of religious communities and with Intact Denmark in, I can't remember if it was 2016 or 2017. His conclusion at the time was that legislating regarding non-therapeutic circumcision would be in conflict with the Danish constitution and with human rights. But of course, the subsequent not ruling, but the subsequent assessment by the Minister of Justice or the Ministry of Justice was contrary to that of the Special Rapporteur. So this is an issue that is on its way in the UNCRC. How do we bring it further? What do we do now? We're reporting this year again, and we would like some tips.
Yeah. When I was writing that article with Merike, I think that in our conclusions we mentioned something like that about that if the ban would ever come, ban to circumcise, it should maybe come, the idea should be from the religious communities, you know, if they themselves make initiative, maybe then it would be easily maybe done than if it's kind of people outside those communities. But I think that it's very important that people do raise this up. What we also thought in our conclusions, what we wrote, that because it seems really clearly that it's Nordic countries, I'm not sure about UK and US, but Nordic countries that have taken this view, children's rights view. I haven't seen this, for example, when I travel in African countries. I haven't seen this anywhere else. So it's quite a small part of the world that is taken. And we thought that, has this something to do with the fact that in Nordic countries, the meaning of religion has diminished quite a lot. And the religious is also considered very individual issue. And if you think then about some other parts of the world and other communities, then the religious is kind of community issue also, and not so much individual issue. So that we have been, in Nordic countries, then the first to raise this up and say that somebody has to be the first. I'm kind of happy and proud that Nordic countries are in the front line.